We are meeting pursuant to Texas Education Code 313.051 to consider a petition for detachment and annexation of school territory filed on April 2nd, 2015 by Mr. Richard D. Melton to detach an inhabited neighborhood known as Thornwood Section 2 and Thornwood Section 3 from Katy Independent School District and annex the same to the Spring Branch Independent School District. This hearing will be an open session. Prior to tonight's meeting, a copy of the petition, which contains the petitioner's proposed findings, and a copy of the administration's proposed findings, as well as the exhibits attached to both of these documents, have been provided to the board. The general substance of the petition requests detachment of Thornwood Section 2 and Thornwood Section 3 from Katy ISD and annexation to Spring Branch ISD. The area is located at the southwest corner of Eldridge Parkway and Memorial Drive at the intersection of Katy ISD, Spring Branch ISD, and Houston ISD. I will now ask each member of the board whether he or she is able to serve as an impartial member of the hearing body and to arrive at a decision based solely upon evidence presented at this hearing. Any member not able to act in such a manner shall say so and ask to be excused. So Pam, please state for the record whether the board member can serve, whether you can serve as an impartial member of the hearing body or wish to be excused.
My name is Pam Goodson, and yes, I can serve as an impartial member.
My name is Bob Stevenson, and yes, I can serve as an impartial member.
My name is Chris Gonzalez, and yes, I can serve as an impartial member.
My name is Catherine Dawson, and yes, I can serve as an impartial.
My name is Wayne Shopper Sr., and I can serve as an impartial member.
My name is Karen Peck, and I can serve as an impartial member.
And my name is Chris Vieira, and I can also serve as an impartial member of the hearing body. I will now instruct the parties on procedures to be followed in this hearing. Both the petitioners and the administration may present information through individuals, documents, or other sources. Any persons affected by this petition may also present information to the board. However, this is not a court trial. There will be no cross-examination, nor will there be any objections or other trial-type procedures. We simply intend to hear from the petitioners and from the administration and any affected persons who wish to speak in an orderly and complete way, and then render a decision. Board members are to remain impartial and are not to be questioned by representatives or participants. The rules for this hearing are as follows. Only one person talks at a time, no interruptions. Questions or disagreements will be addressed to me for my decision. The representatives are not to argue directly with each other. The audience may not talk in any way or interrupt the proceedings. The hearing participants should conduct themselves with common courtesy and respect for the rights of others. Unduly repetitious or irrelevant information will be ruled out of order. A staff member will be making a recording to serve as the record of this hearing. In order for the recording to be understandable and complete, I ask that each participant identify himself or herself each time before speaking, and that all participants stop speaking if there's a problem with the recording until it is solved. And again, a request that only one person talk at a time. The board will give everyone a reasonable opportunity to have his or her say. The hearing will proceed as follows. We will hear first from the petitioner, who should present all of the information in support of the petition. Mr. Melton will have 20 minutes. At the conclusion of this presentation, we will hear from any other parties affected who are in favor of the petition. Then we will hear the information regarding the administration's position. And lastly, we will hear from affected parties who are not in favor of the petition. Affected parties will each have 3 minutes to speak. Are there any questions regarding the hearing and procedures? Yes.
Can we order our speakers? There's kind of a logical order to how we're going to speak.
The speakers in favor?
Yes.
That's fine with me. I don't have any
Okay,
issue.
so just go talk to David.
Maybe Ms. Gerald, or you want to do it? Scott will do it. Okay, so you can see we have the time. You'll be able to see how much time you have left as you come up and present. So, Mr. Melton, we ask that you can.
Good evening, distinguished trustees and Dr. Murray and members of the community. I'm Richard Melton, an attorney licensed in the state of Texas and legal counsel for the petitioners. We respectfully request that you grant our petition for annexation and detachment explicitly allowed for under the Texas Education Code. In a detachment and annexation hearing, the boards of the applicable districts are charged with the express duty to consider the educational interests of the current and future students and the social, economic, and educational effects of the proposed boundary change. And if the benefits to the families outweigh the hardships of the district, you are compelled as a matter of law to grant this petition. And the law clearly leans strongly in favor of families and children. We approached the Katy ISD board with this same emphasis. Katy, on the other hand, improperly jumped past the social, economic, and educational analysis explicitly required under the code. And instead, they went straight to a decision to deny the petition based on a ratio related to proportions of assessed values and students residing in the district. What Katy did not understand was that under the law, the ratio issue was not yet relevant and might never become relevant. The Commissioner of Education has made it clear in an analogous case that breaching the order of the statutory process was not an option that Katy was allowed to pursue. Katy's disregard for the law undermined the validity of their decision and the integrity of the process. Tonight, in addition to establishing the compelling merits of this petition, I'll be addressing some problems related to use of common legal counsel by both districts, including boards in closed sessions. I'll also prove that Katy breached the statute by denying the petition based on a ratio that had not ripened as a factor yet. Your counsel added findings in your findings to justify Katy's action from last week in this week's findings that was contradicted, has been contradicted by two more current commissioner rulings. I will show that Katy and your district have misinterpreted and misapplied the ratio as a matter of law in any event. The rest of the findings by both districts, as you will hear, disparage the parents and the families. On all of the financial issues, we amount to less than 0.1%. The Commissioner of Education has consistently ruled against districts when such an order of magnitude is presented because the alleged hardships from wealthy districts never outweigh the benefits to the families and children. I'll be presenting substantial legal precedent tonight confirming all of these points, and additionally, that the action taken by both districts thus far and the Katy board last week amount to a travesty. The Spring Branch Board will be faced with taking the right course consistent with the law or ratifying an improper decision by Katy. Before I elaborate on the troubling aspects of this matter, I'll highlight the merits of the case, which should have been the entire focus of this hearing. The most recent applicable case is from 2013 involving the Oakwood Independent School District's disapproval of a proposed detachment. The Commissioner of Education overturned the district denial and granted the detachment and annexation. The Commissioner held that the social factors favored granting the petition. One reason was related to the affected territory's proximity to the attaching district. More residents, I quote, are likely to drive, and I will substitute Spring Branch and Katy in these statements so they make sense. More residents are likely to drive into Spring Branch for school, shopping, recreation, and worship than to drive to Katy. The population of the affected area has more social ties to Spring Branch than it does to Katy, as the commissioner said. The detaching district argued that detachment would harm them financially. The commissioner concluded that the benefits outweighed the detriments. In a case involving Carrollton Farmers Branch in the Dallas-Fort Worth area, the commissioner dealt with an argument being made tonight by Spring Branch related to the impact of sending money to the other districts. The commissioner pointed out several relevant considerations for wealthy districts. Carrollton had an appraised property value of $8.2 billion, and the affected territory had a usable tax base of around 53.2, just for your information, because that comprised approximately 2% of the appraised value of the district. Spring Branch has approximately 24.3. Our affected territory is anywhere from 45 to 55, depending on which table you look at. And based on that, we comprise less than approximately 0.2%, 100 times smaller. The commissioner evaluated the net losses and economic impacts of the district, including considering that for wealthy districts, a portion of the taxes collected in excess of the maximum wealth per student would be sent to other districts in the state, the poorer districts. The commissioner's analysis and findings in this case show that losses and economic impacts related to a detachment of an affected territory comprising 2% of the appraised value of the applicable district would not cause financial hardship that would outweigh the benefits afforded to the students in the affected territory. For our matter, Spring Branch appears to be arguing that the attachment of Thornwood's affected territory, a 3 Short Street neighborhood, would cause Spring Branch to send more money to poorer districts to the extent of creating a financial hardship for the district. According to the Texas Education Agency data, the annexation of Thornwood would increase the level of wealth per student by less than a tenth of 1%. The commissioner would hardly call that a financial hardship. Even though argued by the district, legal precedent would hold that the detachment and annexation of our affected territory will not cause a financial hardship that would outweigh the benefits afforded to the students in the affected territory. Of interest, the commissioner added, it is not beneficial for students to spend an hour and a half on a school bus each school day. The children could be involved in more productive activity. Some parents do not let their children drive to Katy High School because of the congested freeways. This is the Dallas area. And by the way, you will hear the administration tell the residents that they've just got to get with it, and you're in Houston, so take it on the chin. In a case involving Marble Falls, a very particularly applicable case, even more so, 2 aspects of it stand out. The school finance system, as the commissioner said, is designed to compensate for fluctuations in property value. In the case, the commissioner held that the overall economic effects of granting the detachment and annexation would not be significant. Now, the affected territory in Marble Falls was located in Austin, on the Austin side, geographically, with the Marble Falls schools to the west-northwest. I would imagine you know where that is. The distances are analogous to our case. The real takeaway from this case is as follows. Distances alone tell only part of the story. Both sides have referred this to as an issue of convenience, but more specifically, it is an issue of time. Time is a limited commodity. No one can make additional time. Now, these are not my words. These are the Commissioner of Education's. He goes on, and he notes that, in this case, we'll use Katy and Spring Branch. Katy schools are located in the opposite direction that one would drive to the most expeditiously to reach Austin or Houston. A significant number of those who reside in the territory work in Houston. Katy and Spring Branch have argued that our families and students just have to get over the distances and driving issues because that's what we are supposed to accept and expect because we live in the metropolitan area. The Commissioner of Education doesn't think so. He stated, if the proposed detachment and annexation were granted, such parents could easily drop off and pick up their children or attend their children's event on the way to and from work. And I'll rapidly go through his points. The convenience of Spring Branch schools could easily make the difference between students participating in rather than not participating in the extracurricular activities. It could make the difference between parent volunteering or not volunteering. The ability to get one's children's schools expeditiously is an important consideration. Excluding the affected territory itself, the residents of the affected territory have more friendships, relationships, and business and social ties to Spring Branch. It is a good thing for students to attend schools with their neighborhood. This makes it easier for families to help families with carpooling and watching each other's children. It is also good for children to have ties to their classmates outside of school. This helps build community. This helps build community, says the Commissioner of Education. Now quickly back to last week. Like Spring Branch, Katy ISD received our petition months in advance. Yet only 10 minutes before the hearing, Katy's attorney dropped a sizable packet in my lap, including as its first substantive point, a finding that the Katy ISD board had decided to deny the petition because of the ratio that Katy ISD had calculated. They stated that the petitioners were in violation of the code because the petitioners did not present the information for the ratio. Katy misinterpreted and misrepresented the code. Katy and their counsel turned what was supposed to be a hearing addressing the economic, educational, and social aspects of the proposed detachment to a completely unauthorized hearing based on a legal issue related to the ratio. Moreover, Katy made such a change without providing the petitioners time to examine and prepare for such a development. Katy clearly avoided the possibility of a thorough analysis and related rebuttal either prior to or as part of the hearing. In the few minutes I had, I was able to determine that Katy had made a gross error. During my presentation, I made them aware of this error. I cited a few excerpts from legal decisions I recalled from my preparation, and I introduced documentation that I pulled out of my file that sufficiently demonstrated that the petitioners could and would meet the ratio if the issue became relevant and necessary, which it was not. Nevertheless, Katy administration and the board, with what appeared to be the aid of their legal counsel, proceeded to perpetuate the hearing without any adjustment. They recessed, it appears, again with their legal counsel, reconvened within approximately 10 minutes with a fully drafted resolution in hand, merely adopting the denial of the petition based on the ratio without any revisions reflecting the challenge I made as to the error in the application. They made no adjustment to offer the petitioners additional time to submit further analysis, and arguably knowing that they had withheld information. They proceeded to affirm their breach of the statute with a unanimous vote. This ambush initiated a process that yielded an unfair hearing, and a decision by the Katy board that is arbitrary, capricious, and an abuse of discretion. The Commissioner of Education has addressed this circumstance before and called out the intrinsic unfairness. Pardon me. In Northgate Forest petitioners, the Commissioner found that the school board's decision was arbitrary, capricious, and an abuse of discretion because the board voted to deny the petition for detachment and annexation because the ratios were not met. The Commissioner went on to explain how the various elements of the applicable code needed to be applied by the parties. The Commissioner repeated, at the board is to consider the educational, social, economic effects. The Commissioner highlighted that while the factors for meets and bounds, majority signatures, and reduction of land area to less than 9 miles were unwaivable, the ratio was waivable. Moreover, the ratio does not arise or become a factor for consideration until and only in the event that the board from the detaching district fails to approve the petition by majority after properly exercising its duty to weigh the benefits versus the detriment. Thereafter, the petitioners have the burden of proof to demonstrate the requirements of the ratio have been met if the petitioner should decide to approve the appeal process. The Commissioner overturned the board's decision to deny the petition, and hear this please, and confirmed petitioner's right to appeal based on the unfairness rule. And while the board cited the code holding that an appeal was not permitted if both boards disapproved the petition, the Commissioner noted that the petitioners were not appealing the decisions, plural, of the both boards, but rather they were appealing the decision of one board. The Commissioner highlighted that had the board approved the petition by a majority, the ratio issue would never have arisen. Katy's action last week substantively mirrored the actions of the board in this case, and their decision would be reversible under law. Katie's board has now triggered a new avenue for appeal based on the unfairness of one of the decisions by either of the boards, including the decision of Spring Branch. A hasty decision, knowingly ratifying Katie's travesty, would arguably cast a worse light on Spring Branch. Add to the fact that possibly that you would be viewed as having relied on advice from common legal counsel at this critical juncture that has acted at least with the appearance of a conflict of interest, including defending Katie ISD's action from last week in the findings for Spring Branch this week. Your legal counsel even added a case in this week's findings that justify or attempt to justify Katie ISD application ratio. They are saying now you are prepared to do the same thing for the same reason. Katie is wrong. Your common counsel would be wrong, but you do not have to be wrong. You don't have to take an action that would ratify an invalid act and therefore add a new violation. The net effect could make your action voidable as well. The Texas Open Meetings Act holds that an action taken by a governmental body in violation of the act is voidable. Your decisions could also become voidable if you somehow meet the requirements of the Texas Open Meetings Act, but then take an action ratifying an invalid act in an open meeting. You are an independent school district. You are in the position you hold tonight because people expect you to act with integrity, employing your skills, critical thinking, and identities as individual human beings charged with protecting the families of the children that you must educate in accordance with the Texas Constitution. You must be true to your oath and you must respect the law. I tell every one of my clients after providing legal input that they must make the decision. It is not the lawyer's decision to make. As trustees, I ask you to be leaders worthy of the trust we have empowered you with because your decisions directly affect our families and children. We respectfully ask that you act independently and differently from the Katie Board and to carefully consider the merits of this petition and additional information you hear tonight. I make this very direct request because your counsel has submitted your findings, including a decision to deny the petition on the exact same ratio basis that Katie so egregiously mishandled. It became apparent that the Katie board members had not read the petition, and they couldn't even engage for 20 minutes to learn about what our family spent a year and a half to prepare for. Katie's actions and the actions of your common council, and so far your district, as you are about to witness in the next 20 minutes, have implicated the Spring Branch ISD Board as a potential party to a challenge before the Commissioner of Education on a matter related to an abuse of discretion by trustees. Consider the following, and I will be running short on time. I believe I've said enough on that. The two boards are supposed to be independent. Katie is a third party to your proceeding, and you are a third party to their proceeding. You are each third parties to each other. The outcome of whether detachment and annexation will occur relies strictly on whether one or both of you approve or deny the petition. The detachment statute states that if you both deny the petition, petitioners cannot appeal. How could anyone conclude that two participants would be permitted under law to collude or share files or have the same law firm that you meet with behind closed doors, that when combined can operate to strip petitioners from the legal remedy to present their petition de novo before a fair and neutral body? That is not due process. And I have many more implications, but I do not have time for it. So I will move. I have a discussion about the two cases for the ratios, but that will come another day. There are two later cases that contradict, prove Katie wrong, and prove that the application that our neighborhood uses is correct. And I'll be glad to share that at another time. Even if I had all of the allotted 20 minutes to just talk about the merits, I would have relied on you having read the petition independently. So in light of these developments, risk, and consequences, I ask to make sure you have read or do read the petition carefully, including the representative affidavits of parents and other sincere persons. The process of pursuing the proposed detachment and annexation has strengthened the community, is what the commissioner said. And in the Marble Falls case, he concluded that coupled with the conclusion that the educational effects between the two good school districts and the economic effects are neutral, overall, the social effects strongly favor the proposed detachment and annexation. If the proposed detachment and annexation is granted, parents will have more opportunities to participate, children will have more opportunities to participate in extracurricular activities, the community will be strengthened, and then the commissioner went on to deny the petition. So in closing, I'm finishing, you have a unique opportunity to do something other than your usual duties by making a decision that will directly and substantially improve. May I just have 30 seconds?
You can have 30 seconds.
Thank you. To directly and substantially improve the lives of the families and the children now and for generations to come. The hallmark of your legacy may be defined by how you handle this critical matter. We respectfully ask that Spring Branch Independent School District act independently of the Katy School District rather than following the incorrect and improper steps of Katy's board. Transcend the law would be my plea. I am asking you as trustees to approve this petition, not just because we have met every legal and demonstrated overwhelming evidence compelling approval, but also because doing so is right, just, and more beneficial to the economic, social, and educational interests of these families and their children.
Thank you. Okay, now we have some parties who are affected and who are in favor of the petition, and we've been given an order, so I will call you up by name, and if you could please come up and give your name and your address and whether you signed the petition or not, if you're just in favor of it. So the first person is Colleen Laughlin. Did I pronounce that correctly?
Yes.
I live at 702 Bison Drive. I did not sign the petition. I'm not registered to vote here, and I'm registered to vote in Lubbock. Good evening. My name is Colleen Laughlin. I'm a resident of Thornwood Section 2. I attended Wolf Elementary, Memorial Parkway Junior High, and Taylor High School. I graduated in 2011, and I'm here to share my personal experiences as someone who lived in the Energy Corridor and commuted all the way up to Katy for schooling. My experiences in commuting can be described by one word: tired. I was scrambling for time, disconnected, and socially isolated for 7 long years. All of my school-related activities were held in the Katy area. I would constantly beg my parents to move out to Katy so I could be closer to my school, my friends, and my extracurricular activities. I was viewed as an outsider to the community, negatively labeled one of the wolf group. Parents of my friends were unwilling to drive their children to the Memorial area to engage in activities near or at my home due to the distance. It was in cases such as these that made it clear to others, Katy is a community, and we're outside its borders. In order to stay socially connected to my peers, my parents drove me to Katy many times in rush hour traffic, many late evenings, which would turn into an hour-plus round trip commute for them if traffic. Thornwood students live in what I would call a black hole. I lived stone throws away from thousands of peers who could have become my community had I attended Spring Branch. It simply does not make sense. I can sum up my junior high and high school years in one word: tired. I had to be at the bus stop by 6 a.m. for a school that started at 7:30 in the morning. This was an understandable burden of mine, was so hard to bear because the bus had to make a return trip on I-10 in the morning during rush hour traffic to pick up the elementary school students. This long commute and early school start caused me to be sleep deprived. In fact, many mornings I was late or even missed completely my first period class because I was simply too tired to wake up at 5 a.m. to make the bus. My working mom had to drive me to school in the opposite direction from time to time from where she worked, causing her to be late for her own job and adding an additional 45 minutes to her commute. Because I did not have access to a local community support network, I was not able to take advantage of after-school tutoring, to put it plainly. I needed help with my academics and was prevented from accessing it. Because my parents both worked, I had no one to bring me home. When I began driving myself at 16 years old, the commute was terrifying for me and my older brother. Due to the lack of driving experience and the fact that I had to drive on I-10 in rush hour traffic in the morning, why I could be taking city roads such as Memorial, and I was tired. As parents, what kind of commute do you want for your 16-year-old children? Commuting became a financial burden, as well as having to refuel my car once per week just to get back and forth to school. This was even worse when it came time for extracurricular activities, not immediately following school dismissal. I would drive to school in the morning, drive home after school. Okay. I have one last thing to say. I'm asking you to support this petition to improve the quality of life and access to education and opportunities for the Thornwood students and their families. It's too late for me, but it's not too late for them.
Okay, next is Brian Thomason, is that correct?
Brian Thomason, I live at 731 Langwood Drive. We did sign the petition in favor of the petition. Here we go. Good evening. Again, my name is Brian Thomason, a Section 2 resident of Thornwood. The beautiful child sitting in front of you is my daughter, Mary. I want to speak about our family's experience with Katy ISD, how it affected our quality of life, and why we wish for our children to attend Spring Branch ISD. In April 2012, our daughter was diagnosed with autism. That label doesn't define her, but it helps sort out some difficulties she has adapting to daily life, including within a classroom setting. In June 2012, she was evaluated for PPCD placement by the Katy ISD Special Education Department. The program that best met her needs was referred to as ECEC, a full inclusion program located at an early childhood center off Pin Oak Road past the Katy Mills Mall. It ran 5 days a week from 8:20 to 11:20. Every morning from September 2012 to May 2013, my wife drove our two children, ages 3 and 1, to ECEC. The daily commute for our child to have access to this 3-hour program was 1 hour and 45 minutes, for a total weekly commute of 8 hours and 45 minutes. 8 hours and 45 minutes of driving for 15 hours of instruction. Katy ISD Transportation said since we lived at the farthest edge of the bus route, she would need to be picked up at 6:45 a.m. That option was out of the question for several reasons. In spite of the immense hardship such a commute posed for our family, for our daughter at age 3, every transition was a hurdle. Due to a sleep disorder common with children sharing her diagnosis, she had to have at least 12 hours of sleep each night. We put her to bed at 7 and woke her up at 7 to begin getting ready for school. A 6:45 bus pickup would require that she go to bed at 6 each night and out of bed by 6 each morning. A different bus driver each day would have been exceptionally difficult to manage as well. Even dropping her off daily to the same teacher was a challenge due to the transition from being with her family to being at school. These issues, compounded by a potential 1.5-hour one-way commute via bus for a 3-year-old child with special needs, made Katy ISD bus service inaccessible. It was offered, but we could not reasonably access the service. Day after day, month after month, my family made this trek to Katy knowing if we were zoned to Spring Branch ISD, we would have driven to Wildcat Way, a 7-mile drive from our home, or Meadowwood Elementary located 2 miles from our home. We explored the option of an out-of-district transfer after hearing about it from some of our neighbors. Since we were accessing both pre-K and special education, this was not an option available to us. After 1 year of that trek to ECEC and a second-year assignment to an equally remote school, we made a difficult and expensive decision to send our child to a private special needs school at a price that began at $20,000 per year in 2013 and has now risen to $30,000 per year as of this year. One other thing that I'd like to note is we're not able to reasonably access the Katy ISD programs geared towards the gifted child with special needs. We are not able to access the special programs within Spring Branch via the district add option or transfer option. In spite of our close geographic proximity to such programs, our perfect case scenario to improve our quality of life is that our tiny 140 home neighborhood be zoned with our neighbors in Spring Branch ISD. Thank you.
Okay, now, next is Nicole Rush.
I'm Nicole Rush, and I live at 702 Thistlewood, and I'm in favor of the petition.
Did you sign the petition?
Yes.
Hold my pen a little bit.
I would like to read a letter from a previous resident who attended Katy ISD and who currently resides in the Spring Branch ISD community but wasn't able to attend this petition meeting. Sarah Norwood's story provides a first-hand account of what an important decision you are tasked with today. In Sarah Norwood's words, I'm writing in support of the Thornwood Petition for annexation into Spring Branch ISD. I grew up in Thornwood and graduated from May Creek High School in 1996. My support for the inclusion of Thornwood into Spring Branch ISD is based on personal experience and not simply a result of a number crunching. The academic education I received was good. I did well and went on to the University of Texas. Unfortunately, academics are only one piece of the educational experience that takes place in school. Living approximately 7 miles, a minimum of 15 minutes without traffic, from my zone school created a geographical segregation that prevented my building a sense of community and connection with my peers in school. The logistics of early morning and after-school practices were complicated by the increased distance and limited carpool options. The Katy Freeway is the most prominent way to get to Katy ISD and not the best options for kids learning to drive, nor parents leaving work to pick up children after school activities or taking children to early morning activities on their way to work downtown. Doesn't it seem silly that I was required to drive 7 miles on a freeway to high school when I could have ridden my bike 1.5 miles down the road? My husband, young children, and I moved back to Houston in 2008. I knew I wanted my children to have a sense of community and connection with their peers in school. For this reason, we moved into a Spring Branch ISD neighborhood instead of the neighborhood where I grew up, where my father still lives. I did not want my children to feel the same separation that I felt growing up. I know several young families currently live in Thornwood that have requested transfers to Spring Branch ISD because they also want to feel a part of their community. These families go above and beyond to volunteer and create routes for their children. Proximity is a large part of feeling connected to your community. Going to the grocery store and seeing your classmates, running errands at the bank and seeing your teacher, dropping your pet off at the vet and having a shared history of the community around you, sending your toddler to a Mother's Day Out program knowing most of the preschool classmates will cross paths with your child again in elementary, middle, or high school. Please strongly consider voting in favor of this petition so that the residents of Thornwood can grow their roots in the community and have a sense of belonging. Thank you for your consideration.
Jeffrey Castro.